Welcome to our program on immigration and you. I am your immigration attorney, Michael Fulwani, and once again, we have with us my law partner, David Nachman.
Thanks so
David,
much, Michael.
welcome.
Always a pleasure to be here.
Thank you.
Of course.
Now, if you guys recall, in the last programs, we started telling you about the information that President Obama announced on Friday, November 21st, about his executive action under which more than 5 million people will get a deferred deportation and also permission to work. And there are many other things we talked about in the previous two programs. And also we did show clippings from the speech that President Obama gave, and we've been continuing to give a part of that each time. And so let us today, before we start the program, give you a piece of that information that President Obama is talking about. So let's go to the tape. Well, I hope you listened to President Obama, what he said. And continuing our information about this executive action memorandum that has been issued, I'm going to ask David to give you some information on the side of employment. Basically, what we did the last time, let me remind you about that, because if you missed any of those items, programs, you can always email to us. But we covered the DACA program. We covered
Exactly. Well, there were several components, Michael. The first one that we discussed was the expansion of DACA.
Yes.
And that had to do with the fact that now you don't have to be under 31 years of age. You can actually be over 31 in order to get the benefit.
We also covered the expansion of waivers.
We also covered provisional waivers, the expansion of provisional waivers, and we covered the expansion of the DAP, which is the deferred action for parents.
Right.
And these are parents of individuals who are U.S. citizens or lawful permanent residents in the U.S., and that they had to be here 5 years continuously and physically present in the U.S. on November 20th when the president made his announcement, which was November 20th. So
let's talk about the on the side of.
So now on the business side, yeah. So on the business side, of course, there were some very interesting developments, and I think that what we need to do is to just make our viewers aware of what was going on in the what is going to be going on in the business arena. So first and most importantly, there was some discussion about the fact that H-4 dependents, of course, were going to be able to work. And we actually made that announcement on a previous show.
It may happen.
Yeah, well, it is going to happen. Actually, they said that.
Previously, we said
yeah, previously it may happen, but it is going to happen. And the thing is that we're just not sure what the date is going to be. But apparently, they're in the final rule stage. So dependents of H-1Bs, H-4s, will have an opportunity to work, and it's a matter of just making sure that the individuals who are H-4s, their H-1B dependent, their H-1B spouse has applied under the rules to extend AC-21 to extend their H-1B into the future. So remember that you have to apply prior to the 5th year for a green card, and if you've done that incremental increase, either the 1 year or the 3 year incremental increase on the H-1B, you'll have an opportunity to apply as an H-4 for work authorization.
There's a slight difference in what we talked about DACA and 601 waivers. Is that defines exactly says what is the requirements and is going to happen. In most of these items, which probably will happen, basically they are saying like the USCIS will work with the Department of State on this, or they will clarify this and clarify that. So that means that they are going to be discussing, working on it, and then again advising us appropriately, okay, this is the rule that under that we will do that. For example, that you mentioned about the H-4 employment. So once they make a decision, which we think they will, then they will issue another memorandum in which they say that this is going to happen, or we have accepted this, and this is the rule now.
Correct, and that's in its final rulemaking stage.
Yes.
So with regard to the administrative relief on the business side, number one, first of all, there's a memorandum issued on November 20th which deals specifically with the administrative relief that will be granted in the business, or I guess you would say the entrepreneur arena. So the discussion in that memorandum is as follows. Number one, that what they're going to do is they're going to seek to utilize all the visas that were authorized by Congress. And so what I believe that they were talking about there in that provision of the memorandum is that they're talking about making sure that all the visas are used because there are some, there's a concept of the possibility of leftover visas that go by the wayside. So they want to make sure that they use all of the visas. But also, more importantly than that, I think that there's also discussion about the fact that what they want to do is that when they draw on the pool of visas on a fiscal year basis, they want to make sure that there are enough visas in that pool. So there's discussion about the fact that they're going to change the visa bulletin and modify the visa bulletin program. The president has called the U.S. Department of State to work with the USCIS to ensure that the visa bulletin methodology is modified. And it'll be modified in such a way that the individuals who draw upon those visas on a fiscal year basis, the beneficiaries will take one visa out of the pool, as opposed to the beneficiary plus all the dependents taking visas out of the pool, which leaves very few visas available. And unfortunately, that's why we end up with retrogression for countries like India, China, Mexico, and the Philippines.
No, David, this is huge. This you just mentioned to me. I hope that happens. Why is it huge? Because right now, if there's a family of 4, husband, wife, and 2 children, and they give the visa to them, they are counting 4 numbers. So like a basket full of candies.
Correct.
So they are taking 4 candies out and giving
Exactly.
away. So they'll go very fast, obviously. But if they are, the word counting is not there, but I think you and me understand that this may relate to counting only the one principal beneficiary and not counting the family members.
Correct.
So what this will do, there will be more candies available to give 1 to each.
Exactly.
Instead of 4 to each.
Exactly. And
So-
that hopefully solves the problem with the tremendous retrogression that we're seeing in the EB2 category for India.
The retrogression, the waiting period, let us say brother, sisters category is, let us say 12 years, because they're counting for 4.
Right.
But if they count only 1, that 12 may become 3 or 4.
Right.
So each category, whether it's work, whether it's employment, whether it's family,
Exactly.
the waiting line that you see in that visa bulletin every month, sometimes what's the purpose of applying for a brother, sister? What is the purpose of applying a citizen for the married son or daughter? Because
Right.
what's going to, they're not going to wait 12 years, 13 years, 15 years.
Exactly.
So this is a huge thing.
Exactly.
And I hope that happens, and our viewers will be very, very happy that their family members, parents, and other people will be able to come faster.
Exactly. The next point that the president makes in this memorandum, which again, I'll point out to you, if you don't have access to this memorandum, please send us an email. We're more than happy to provide it. It is listed on the web. It's a November 20th memorandum, and it also talks about rolling back AC-21 benefits to the time when the I-140 is approved, as opposed to waiting till the I-485 is approved.
So
This, of course,
practically, let's talk about that. What will that do?
Well, this gives individuals the opportunity to be able to move their employment to a new employer without waiting till 180 days after the I-485 adjustment of status application has been filed. Now they'll have an opportunity.
Keeping the same file, keeping the same priority date, keeping the same approval in place, and moving will not disturb that, will continue.
Exactly. Well, actually, Michael, the way it works is that the concept behind this is that under AC-21 is that the labor certification, there's a personal interest that the individual gets in the labor certification process 180 days after they filed adjustment of status. So it's a property right that goes directly to the individual. So I think what the government is saying is that they're willing to give that property right in the labor certification to the individuals who are waiting prior to, now even prior to this, the filing of the 485, they're going to do it at the approval of the I-140. So what this does is, again, if the individual is in the same or similar occupation, which is another thing that's addressed in this memorandum, is what is meant by same or similar occupation. So what they're going to be doing is they're going to be clarifying for the public what is considered to be same or similar occupation, and that is going to be a liberalization to allow individuals to be able to move to other occupations that are, again, same or similar
So if there was
occupations.
no provision AC-21, these people are forced to continue to work for the same employer, even if they are not getting good pay, even if they have opportunities to go better jobs with a higher salaries. So it makes them free out of that. You can say goodbye. You can say goodbye to the present employer and just move on to
That's exactly right, Michael. And in fact, you'll remember that going back to Acquia, or the and the other laws that were passed, AC 21, implemented a provision called portability for H-1Bs, and that had to do with the same thing, is unchaining the H-1B and allowing them to move around, because we obviously favor free market employment as opposed to chaining someone to their desk and making them stay at a job because their immigration status is pending. So what this essentially does...
In the H-1 cases, the new employer had to file a new petition to move from. But
That's
in
right,
this case,
but
there's no new petition or anything.
That's exactly right, but it still gave them the
Yes.
ability to move. And so I think that that is part of the underlying policy. There is also discussion in this memorandum about reforming the optional practical training that foreign students have in the United States to allow them, basically it expands the degree programs to allow for STEM extensions for more science, technology, and engineering, mathematics fields of study. So this is also consistent, and of course, that extension, of course, needs to be consistent with protections in the U.S. labor market for U.S. workers to ensure that they're not being displaced.
What about national interest waiver that they're expanding it in a way, or making it easy, am I right?
That's exactly right, Michael. That was my next point, and that has to do with the fact that in order to promote research and development in the United States, the President has submitted a administrative relief, or he's taking an administrative action with regard to the liberalization of the national interest waiver. National interest waiver is an EB2 classification. As many of you may be aware, you may be the beneficiaries of national interest waiver petitions. They are self-petitions. They don't require a labor certification, and the individual can self-petition. So it's a very strong, powerful green card classification. And essentially what the government is saying here, at least the President is saying, we're going to liberalize the national interest waiver.
But so far it has not been that easy. You know that it's very tough to get it done. So this one is going to kind of make it easy.
Exactly. Easier.
Liberalize.
Exactly. And then there's discussion, which is really interesting, about the implementation of a parole status for inventors, researchers, and founders of startup corporations, where they'll be paroled into the United States for significant public benefits. And basically what they're doing is they're earmarking this for those who are awarded substantial U.S. investor financing, or who hold promise through innovation and job creation through development of new technologies and cutting-edge research. It almost seems like what they're doing is cutting that out for the folks in Silicon Valley, or who have startups who are developing jobs for U.S. workers.
And they do not need a visa? Or
well, that's the interesting thing. It's almost like a form of deferred action, Michael.
Exactly.
What they're doing is they're giving a parole. It's almost like we talked about parole in place for military families, and essentially what this is parole in place for entrepreneurs, or parole in place for researchers. So it seems like what they're going to do is they're going to have this allowed as a fallback position in the event that our researchers, our scientists, our entrepreneurs can't get the H-1B or can't get some other form of status. Rather than to get rid of them, we're going to have an opportunity to take another bite at the apple and allow them to possibly be paroled into the United States and have a work authorization and be here, which gives us a little breathing room to try to get them some sort of status.
So they don't have to go to the American consul to apply for a visa, which may be granted or denied.
They'll be able to do it here.
So that's a lot of people, they don't get the visa, so they can't even come.
Exactly.
Okay.
Yep. So those are on the business front. Those were the forms of administrative relief that were talked about by the President in this memorandum. Obviously, this also comes on the heels of a discussion by the Department of Labor of changing the PERM process altogether. And there was some rumblings about the possibility that there would be allowed an expedite fee for PERM. We don't know where that's going to go. I am personally not I'm not too optimistic about that. However, there were some rumblings about that and modernizing the PERM application process. So that we're just waiting to hear about. So
something about the naturalization, not much though it said, they will promote the naturalization process, like you can pay your fees by a credit card and maybe make it easier. I don't know exactly. But they're looking into that. I wish they would have eliminated the requirement of English language for the elderly parents. Many times we talked about that, but that needs a Congress action.
Exactly. Well, I wish they had eliminated the 3- and 10-year bars, but they need Congress for that.
That's
too.
the whole thing about this is
right.
whether the whatever he's doing, falls within the purview of his powers, or he's going to do outside of that. And there's going to be a big fight. You'll see that right away as the president stopped talking. This Republicans leadership came in, and every time, all the time you see on CNN, Fox, and other news that they are saying we're going to kill this, we're going to not give them the money, we are to go to the court, we are going to make new law to eliminate every kind of. They are very angry. They just don't want this to happen.
Well, I think that that's a perfect subject that we should take up at the beginning of the next program, Michael, is what potentially could end up happening with regard to this new administrative relief in the future. So with that, I know we're running out of time. So
quickly, can you say when can they file, our people, this, how many, 6 months, 3 months, they have to wait?
Unfortunately, on the business side, the memorandum does not set forth any timeline. So we'll obviously do what we can to keep our viewers apprised of when these administrative reliefs will be available to them.
So keep in contact with us and keep watching the program. We'll give you all that information in our forthcoming programs. Thank you very much, David, for being with us today. And thanks
so much,
all
Michael.
of you for watching the program. And goodbye.